Okay, people. So here is, look at the date. Do you see that? It says September 25th, 2017. Here we have the one for November 3rd, 2017. This is the one that I read yesterday. Okay. Here, they actually did acknowledge the amendment that I put in, and this is what they said. Fraser Health Authority. We are in receipt of your amended notice of... I'm going to have to go like this. Hold on. I don't want to read through the lens. I got this camera plugged in too. Do you see? Look at my sewing table. Okay. We are in receipt. My Lord. Try this again. We are in receipt of your amended notice of civil claim. Although the statement of facts has been condensed to approximately 20 pages, there are nearly 60 additional pages of Part 2 and 3, 2 case sensitive in terms of sound, vibration. Look at that. Okay. I unplugged it. The connections in this little camera are loose, right? Being manhandled all these years. Anyway, facts has been condensed to approximately 20 pages. There are nearly 60 additional pages of Part 2 and 3 for your notice of claim, for your notice of civil claim, which have not been amended. At the case planning conference on August 15, 2017, Master Taylor directed that your entire amended notice of civil claim was to be no more than 15 to 20 pages, not just the statement of facts. You are in violation of a direction of the court. In addition, the notice of civil claim is amended. In addition, the notice of civil claim, as amended, still discloses no reasonable claim. The allegations you raise against our client, Fraser Health Authority, are in relation to care and treatment received by Mr. John Duncan. Generally, a hospital owes a duty of care to its patients, not to a patient's friends or relatives. We believe there is no basis in fact or law for your claim against the health authority. Accordingly, we have instructions to bring an application to strike your claim. If we are forced to bring this application, we will be seeking a costs awarded against you. If, however, you agree to drop this action before we bring the application, our client is willing to waive the costs it has incurred to date in defending this claim. Okay, this is my little 7-page synopsis of what's going on here. 7 pages, okay? I'm going to take 2 chapters in response to what we're dealing with here. Number 4. Upon taking the responsibility for the plaintiff to represent Mr. Duncan and his immediate family under this application, because you have to remember, people, I've been doing the paperwork for years, okay? That's why Uncle John stuck around, okay? Because I did the paperwork. And his immediate family under this application to continue with the notice of claim filed against Fraser Health Authority and Canadian Imperial Bank of Commerce. The plaintiff has held legal enduring power of attorney regarding Mr. Duncan's general affairs, if there should be any, for a period of 25 years without any disruptions. In addition to, the court is asked to note that Mr. Duncan has an official active will that was written in the year of 1998, to which FHA agents illegally disregarded the enduring power of attorney and Mr. Duncan's will for the benefit of themselves and their friends. Hence, through the Hospital Act, under the title of Conflict of Interest Prohibited, it clearly states, Section 4.12, an employer must not do any of the following. A. Persuade or induce or attempt to persuade or induce a patient to make or change the patient's will, make a gift, provide a benefit for an employee or the employee's spouse, relative, or friend, or conduct the financial affairs of the patient for the benefit of an employee or the employee's spouse, relative, or friend. Act as a personal representative for a patient or former patient unless the employee is a child, parent, or spouse of the patient or former patient. Understand, people, these people would not let Uncle John go home. All right? They kept accusing him of being confused. They kept accusing him of being confused. They were accusing me of elderly abuse, but they weren't being specific as to what type of elderly abuse I was perpetrating upon Uncle John, right? As they were telling him that he was going to go to convalescent care by any means necessary. And if it wasn't there, his second choice was up in the country, way off in the freaking boonies, with people that he hadn't seen in years and has never ever lived with since he was a kid. Hold on a minute. The social workers and the staff were the employees to Fraser Health, where Fraser Health had the responsibility and duty of care to monitor their employees so that the employees didn't make backroom deals with the friends or the relatives, as in Eleanor and whoever else was in the mix, CIBC Bank, to steal Uncle John's money, people. That's the duty of care that they're protecting here. I wasn't just somebody that walked in off the street. That was Eleanor. Eleanor is the one who walked in off the fucking street. 4.13. I have to think like a lawyer. I can't get mad. A provision of a will. A change to a will. We have Cheryl on video recording with Shimei talking about how Uncle John is putting the past behind him, and everybody agrees that it's the great thing to do, as they're telling him that his money is being stolen by somebody in Vancouver, namely by me. Right? And that whatever he decides to do, it's okay with them. In terms of, oh, gee, John, you inherited all this money from Joan. What do you want to do with it? Who do you want to give it to? Not definitely those people in from the past. They're in the past. It is contrary to everything that is written here, people. This is why Fraser Health Authority doesn't want it to go to court. A provision of a will, a change to a will, a gift, a provision of a benefit, or another measure described in Section 2A1 and so on, is void if it confers a benefit on an employee or the employee's spouse, relative, or friend, and the public guardian and trustee was not given written consent to it. They never involved the public guardian and trustee. They didn't contact the public guardian and trustee and got them involved, because if they would have gotten them involved, people, the money would have went to the public guardian and trustee, and it would have been held in trust as everybody was fighting in court for it. And they would have gotten a fee. 4.14. If an employer acts as an attorney which those social workers were doing because they wouldn't even provide Uncle John with an attorney. We asked for an attorney. They gave us a flyer. When we started talking about getting an attorney, they took him away in the fucking middle of the night. Well, actually, it was during the day, in a hammock, passed out, which is equal to the middle of the night. If an employee acts as an attorney or a representative contrary to subsection 2C, the power of attorney or representation agreement and any disposition made under the power of attorney or representation agreement is void unless the employee is a child, which Fraser Health and their employees were not, a parent, which they were not, a spouse, which they were not, of the patient or former patient. They were all government employees. And the only one that had any kind of tie to Uncle John, in this case, was Eleanor. Somebody who had hardly ever spoken to, hardly ever seen, maybe was lucky to see her once in a blue moon at his annual mother's birthday. But outside of that, he didn't live with her. He left home when he was 17, people. Uncle John left home when he was 17. He never went back. When they took him, he was almost 77. So what? He didn't live with this woman for 60 fucking years, and then all of a sudden he shoved in her face? As she's putting her face one inch up to his face, saying, "You can't see the kids. You know that. You're not better yet." But it's all about duty of care. If an employee acts, read that. Therefore, that's a long-ass paragraph. Section. Therefore, when applying the principles of the Community Care and Assisted Living Act, so in other words, this is complementary to that, because they list it in more than one fucking act. Under Section 18(1)(3)(a), blah, 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 titled Certain Advertisement or Inducement Prohibited, for the time Mr. Duncan was temporarily housed at the Yale Road Center in addition to the Surrey Memorial Hospital, it was Fraser Health Authority and their agents who acted with bad faith through intimidations and malicious misconduct that demoralized Mr. Duncan and his immediate family in the name of Chorney, so that false pretense, as listed under the Criminal Code of Canada, Section 3621, could allow FHA agents the ability to appoint themselves to be Mr. Duncan's power of attorney and or representative for the purpose to commit fraud and extortion, while Mr. Duncan and his immediate family were all under duress as FHA agents did so. Mr. Duncan, on many occasions over a period of 39 days, informed FHA agents to talk to the plaintiff about his medical circumstances and or regarding any financial inquiries. If Uncle John would have had a lawyer, this wouldn't have been an issue. Consequently, when requested by Mr. Duncan or by the plaintiff to review Mr. Duncan's medical files, both he and the plaintiff were denied by FHA agents. That's a fact, people. That's a statement of fact. As they continued to accuse Mr. Duncan of being confused while in their care, and then began to accuse the plaintiff of elder abuse. FHA agents used accusations to their advantage and as their reason to not allow for Mr. Duncan to go home to his place of residence, where FHA agents would not come after him once leaving their care facility. Because if he would have decided that he was just going to walk up out of there, they would have came after him, and they would have used their axe to do it. But when they break laws and you come back and you use those same very acts, but only different parts of those acts, and you call them on their negligence, all of a sudden it becomes it becomes the duty of care to him. This is about him, people. This is about him, and then that effect from the cause of what these people did, which affected not only Mr. Duncan, but it affected his family, his immediate family, not Eleanor, not somebody that he hadn't lived with for 60 years. It affected the people who had been looking after him and who he looked after for 23 years plus. As a reminder, under Section 32(1)(a) and (b) of the Power of Attorney Act, it is still the duty of Fraser Health Authority to provide the plaintiff, the attorney to Mr. Duncan's legal and financial affairs, with the requested information where the area of authority has been granted to the attorney, which is me, people, by Mr. Duncan. In other words, I want his medical files before he disappeared under questionable circumstances from a FHA care facility, and to which duty of care to the patient is still the responsibility of FHA. FHA. They don't even know where he went and how he got there, because they didn't care. They put all their fucking eggs in Eleanor. One basket. Right? Because she was the ticket to go out there and scoop out for some more Uncle Johns. Uncle John was just the bone. In consideration to Section 7(1)(a)(b) blah, 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 standard to be maintained under the Community Care and Assisted Living Act. This is the second paragraph I said I was going to read. Looks like another long one. It is the responsibility of Fraser Health Authority to ensure that their agents and various employees are persons of good character and who meet the standards for employees specified in their regulations, in addition to operate the community care facility in a manner that promoted the health, safety, and dignity of Mr. Duncan, and including make his rights both orally and in writing known to him, which they did not do, people, and to his legal representative, which is me, which they did not provide, while in the care of FHA. Consequently, FHA agents breached these two basic legislated principles as they continued to retaliate spitefully against Mr. Duncan's representative, the plaintiff, to whom has had legal enduring power of attorney, I'm reminding them, since October 30th, 1990. Hence, the plaintiff to whom, any matter regarding enduring power of attorney being revoked in any correct manner that would be considered legal has not occurred in any court of law or has been done through the public guardian and trustee under the Adult Guardianship Act. Because it would have had to been through the public guardian and trustee who would have had to taken it away from me. And they would have had to appoint somebody else to take that position through the Patient Property Act and the Adult Guardianship Act and the Mental Health Act. Depends on how they're taking you and from where. Nor has any other application been put forward by a legitimate source through the Patient Property Act, there it is, that could have lawfully removed the plaintiff from her position as the attorney and representative to Mr. John Duncan. What is the point of having somebody watch out for you so that when other people decide they want you, whoever's watching out for you is completely ignored and your life is turned upside down just because they're in a position of power to use taxpayers' dollars to do it? Because if Eleanor didn't have the resources of Fraser Health Authority and the back door of the emergency rooms and all these other fucking places she was going in the middle of the night, sneaking around in the freaking corners, she wouldn't have gotten away with it. Or if Fraser Health Authority was actually monitoring their employees, right, There would have been no safety nets in there to protect Uncle John. But that's not where the duty of care lays. In reference to Section 32, Immunity and Community Care and Assisted Living Act, 1, subject to subsection 2, no legal proceedings for damages lies or may be commenced or maintained against the director of licensing, the registrar, a medical health officer, or a member of the board, or a person acting on behalf, now they're trying to protect their ass here, or under the direction of any of them because of anything done or admitted. However, subsection 1 does not apply to a person referred to in that subsection in relation to anything done or admitted by the person in bad faith. 3. Subsection 1 does not absolve the government. Does not absolve the government. FHA, FHA Health Authority, is an entity of a government. They were brought in 2001 to monitor the government's activities within our healthcare system. A health authority or an employer from various liability arising out of anything done or admitted by a person, well, more than one person, people. This was a conspiracy. Referred to, it took more than one person to pull off what they did. Vicarious liability arising out of anything done or admitted by a person referred to in that subsection for which the government, health authority, or employer would be vicariously liable if this section were not in force. In reference to Section 33, offense and penalty, a person who contravenes section, and then we got a whole lot of them there. All right. Because they wanted it all brought down. This is what you go into mine and you can actually read what those sections are. But they wanted it down to 3 pages. So now you're stuck with numbers, so you don't know what the heck you're reading unless you're going to go look for the various act or look for the Criminal Code of Canada to cross-reference these letters and numbers. Right? And that's part of the game. That's why they don't like them coming in with detail. Because it's easy to hide the detail behind numbers and letters that don't make sense. When everybody's rushed because you're being accused of wasting the court's time. And that what you're putting on the table is frivolous and what else did they write here? Wrote something. Because I'm reading all the time, I'm getting mad, right? Can you tell? A person who contravenes Section 5, of this act or a term of condition attached to a license commits an offense. A person who commits an offense under such is liable for a fine up to $10,000 if an offense under subsection 1 is of a continuing nature 4 years later. Each day that the offense continues constitutes a separate offense. In conclusion to Section 7, standards to be maintained under the Community Care and Assisted Living Act, an act that FHA Health Authority and its employees are supposed to follow. FHA Health Authority had a duty of care to provide Mr. Duncan and his legal representative, the plaintiff, Judy Chorney, a level of professionalism that was equal to the legislation that governs that duty of care. However, through convoluted acts from FHA agents to defame and slander the plaintiff under false accusations of elder abuse for the purpose to commit fraud on an employee level, where the unlawful seizure of the plaintiff's privilege as legal representative and enduring power of attorney was wrongfully removed from her by FHA agents without due process, clearly shows the negligence of FHA Health Authority as a ruling body to their employees. It was the employees as a group who conspired to take over Mr. Duncan's assets at the expense of completely removing him from his immediate family via those convoluted occurrences that has brought this notice of civil claim forward. Right here we've got the residential regulations of the Community Care and Assisting Living Act, release or removal of a person in care. A licensee must ensure that a person in care is not released from the community care facility to or removed from the community care facility by any person except the person in care's parent or representative or a person authorized in writing by that person. So they got John to sign a little piece of note there, paper, saying that Eleanor had the right to take him across the ferry by any means necessary, rush him off into the emergency room on the other side, leave him sit there and rot for a couple of months, right, until she figured out all the fucking paperwork, right? 2, subsection 1 does not apply to the release or removal of a person in care in accordance with the care plan, which Uncle John didn't really have. He should have had one, but he didn't. And if he did, they need to cough it up, because there would be a record of what drugs that they were giving him. You would think that there would be. But of course, Fraser Health Authority can't find those records now. That's what he told the last judge we were in front of. Or was that Justin Bowden? He told that, I think, to Justin Bowden. And Justin Bowden said, "See, lovey." Two, subsection 1 does not apply to the release or removal of a person in care in accordance with the care plan of the person in care or another pre-existing arrangement. Hence, under no circumstances would Mr. Duncan been able to write a letter authorizing any other person to be his representative for the purpose to remove him from the community care facility without having identification upon leaving the facility, or for him to refuse any follow-up on any medications that he had been receiving since coming into care of Fraser Health Authority. Remember, they were telling him that all he was getting, people, was a calcium pill. They were denying through the whole fucking 39 days or whatever it was that they even gave him anything when it came to pain medication. So when they released him with no ID, no clothes, no personal belongings, nothing. They released him into the care of somebody that he had no real relationship with for over 60 years. Okay? Did they release him with a prescription for the medication that they had been giving him from the time that he showed up at the hospital on January 13th of 2015 to the time he fucking disappeared by February 20th of 2015? Did they give him a prescription so that when he went into the emergency room, all he had to do was pass it over to the new fucking physician? Or did his file go over and everybody just turned a blind eye? Right? Because nobody is monitoring the employees of Fraser Health Authority. Right? So, what happened? Fraser Health Authority, they know. Or for him to refuse any follow-up on any medications that he had been receiving since coming into care of Fraser Health Authority. In addition to, if a third party drafted, which would be Eleanor, such a letter, or that social worker, in writing, and Mr. Duncan signed it, that would have been done under false pretense, because they were conspiring behind his back, my back, and the rest of the family's back, as listed under the Criminal Code of Canada, Section 3621, and then there's a whole bunch there, due to Mr. Duncan's blindness, as he would have not been able to read what he was signing even if he wanted to. Therefore, Fraser Health Authority disregarded a 76-year-old blind man who could barely walk without any personal discharge. Therefore, Fraser Health Authority discharged a 76-year-old blind man who could barely walk without any personal identification on his persons, despite FHA agents having a vendetta to have Mr. Duncan go into convalescent care by any means necessary, designed by the FHA team within the first week of him being at the Surrey Memorial Hospital. The first week, they wanted me to sign. Uncle John said, don't sign him over. And I didn't, people, because he wanted to come home.